Imagine walking into a courtroom, right? You are asking a judge for 80,000 Rand to cover your legal bills, 50,000 Rand for monthly maintenance, and you present yourself as a total victim of circumstance.
Only for the judge to throw your entire case completely in the trash.
Exactly. And why? Because you conveniently forgot to mention your secondary income stream. So, welcome to today's deep dive. Today, we are looking at why playing poker with your finances in divorce court will not just lose you the hand, but could actually financially ruin you.
Yes, it is a very serious issue.
We are examining the uncompromising judicial mandate for financial transparency in divorce proceedings. We will unpack exactly how courts are striking back against hidden assets and inflated expenses, and we are doing this as a formal, professional legal analysis designed for you, the listener.
Whether you are a legal practitioner advising clients or an individual navigating the family law system yourself, this affects you directly. The stakes in family law are incredibly high.
Yeah.
People are dismantling their lives.
They feel vulnerable.
They are terrified about their financial future, and the temptation to hide money or, exaggerate expenses is immense. But treating a sworn affidavit like a strategic negotiation tactic is legally fatal.
So, to understand the mechanics of this, we need to look at a practical application in a courtroom setting. Let us look at the recent judgment delivered by Khaba AJ in the High Court. This is the matter of SJJ versus MMJ.
A fascinating case, really.
It is. Now, this case revolves around a Rule 43 application. Just to set the foundation, Rule 43 is the legal mechanism used here in South Africa to secure interim maintenance while divorce proceedings are still ongoing.
That is correct. A contested divorce can take years to finalize. You have discovery, expert assessments, severe court backlogs.
It drags on and on.
It does. So Rule 43 exists to ensure that neither party nor their children are left destitute during that waiting period. It is designed to provide immediate, temporary relief based on current, factual financial realities.
And in this specific matter, the applicant came to the court requesting very specific numbers. They sought 20,000 Rand for monthly child maintenance, 30,000 Rand for spousal support, and a massive 80,000 Rand contribution towards their legal expenses.
Which is a substantial request.
Highly substantial. But the court delivered a remarkably harsh response. The application was completely rejected. Why? Because the applicant committed a material non-disclosure regarding other financial support they were already receiving.
And look, the court refused to simply adjust the numbers. That is what many litigants expect will happen if they get caught.
Right, they think it's just a math problem.
Exactly. People assume, well, if I ask for 30,000 Rand, but the court discovers I secretly received 10,000 Rand from somewhere else, the judge will just subtract the difference and award 20,000 Rand.
A simple recalculation.
Yes, but Khaba AJ rejected the premise of the application entirely. The entire foundation was tainted by dishonesty.
It is analogous to applying for emergency financial relief from a bank, right? You claim you have zero liquidity, but you secretly hold a secondary bank account. The moment the bank discovers that hidden account, they do not just recalculate your loan.
No, they decline it entirely due to fraud.
But I have to push back here, considering the adversarial nature of divorce. You have two parties who are deeply hostile. Is there not an inherent, albeit flawed, strategic temptation to exaggerate expenses simply to establish a stronger initial negotiating position?
Well, that temptation is always there. Litigants often view the first set of papers as an opening bid in an auction. But that is a fundamental error in judgment.
How so?
A Rule 43 application relies entirely on sworn affidavits. There's usually no oral evidence. There's no cross-examination in the traditional sense during these interim applications.
So the judge only has the paper in front of them.
Exactly. The court has to rely on those papers. When a litigant uses an affidavit as a sophisticated negotiation tactic, they're effectively paralyzing the court's ability to make a fair, evidence-based decision.
Because they are destroying the only currency they actually have with the judge, which is their credibility.
Yes. Once a judge realizes you have lied about one financial aspect, they have no reason to trust your stated grocery bill, your electricity expenses, or your child's schooling costs.
The entire affidavit becomes totally unreliable.
The whole thing collapses.
So the judge did not just get angry and throw the book at them on a whim. There is actual legal DNA for this zero-tolerance policy, anchored in long-standing precedent.
Yes, the judgment heavily references the precedent set in Preez versus Preez. That case cemented what we call the clean hands doctrine in family law.
The clean hands doctrine.
Right. It asserts that anyone seeking relief from the court must approach the bench with clean hands. You must be entirely free from deceitful conduct. The duty of utmost good faith is not just a theoretical guideline.
It is a strict operational requirement. But let us test the threshold of this doctrine. Does the clean hands doctrine imply that a litigant must have a record of absolute administrative perfection? I mean, if I submit my monthly expense sheet and I forget a 150 Rand streaming subscription, or I estimate my water bill at 1,200 Rand instead of 1,350, are my hands suddenly dirty? Am I barred from spousal support over a mathematical error?
No, and that is a crucial distinction to make. The courts are not demanding superhuman administrative perfection.
Okay, that is a relief for anyone listening who struggles with spreadsheets.
Exactly. They understand that estimating monthly living expenses involves some degree of approximation. What they are looking for is material honesty regarding your true financial standing.
So it is really about the intent and the scale.
It is about materiality. There is a vast, recognizable difference between an administrative oversight and a strategic omission designed to mislead the court.
Right.
Failing to disclose an existing stream of financial support, as was the case in SJJ versus MMJ, fundamentally alters the court's understanding of the applicant's need.
Because if you have thousands of rands flowing into an undisclosed account, you are intentionally painting a false picture of destitution.
Precisely. That is material deceit, and that is what soils the litigant's hands.
Which brings us to the consequences. And this is where the cover-up truly becomes worse than the crime. Because the court requires clean hands, failing to provide full disclosure directly results in punitive measures.
Yes, the temptation to underreport income backfires spectacularly, leading to punitive costs orders.
And we really need to examine the exact mechanics of these orders because there is a massive misconception regarding what a punitive costs order actually means.
There is indeed. When a litigant behaves deceitfully, the court will often award costs against them on a punitive scale, which is the attorney and client scale.
Right.
However, litigants and sometimes even junior legal practitioners misunderstand the severity and the exact structure of this penalty.
Let us clear this up for everyone listening right now. A punitive costs order is not a blank check for the winning party. It is a very common myth that if the court awards you costs on an attorney and client scale, the deceitful party is going to be forced to pay 100% of your legal bills. That is simply not true, is it?
It is not true at all. The order expands the parameters of what can be recovered from the opposing side, but it does not equate to a total indemnification of all legal expenses incurred.
Let us break down those mechanics. In standard litigation, if you win, the default costs award is on the party and party scale.
Correct. And the party and party scale is highly restrictive. It only allows the successful party to recover the costs that were strictly and absolutely necessary to conduct the litigation.
So it operates on a fixed tariff.
Yes, it does not cover everything you actually paid your lawyer. It covers a bare-bones, regulated fraction of it.
And then we have the punitive scale, the attorney and client scale, which is broader. It permits the recovery of a wider array of items. It allows the innocent party to claim for items that the standard party and party scale strictly prohibits.
Yes. So on an attorney and client scale, you might be able to recover costs for additional consultations that were not strictly necessary for the bare minimum of the case, but were reasonably incurred to deal with the opposing party's deceit.
I see.
You might recover costs for more extensive correspondence between the attorney and the client. However, and this is the vital point, these costs are still subject to taxation by the taxing master of the court.
Wait, let me stop you right there, because when you use the word taxation, the immediate thought is the revenue service collecting taxes. Break that down for me in a legal context.
That is a very common point of confusion. In the legal world, taxation has absolutely nothing to do with government taxes or the revenue service.
Okay, good to know.
Taxation is a formal process of auditing a legal bill. The taxing master is a court official whose entire job is to review the successful party's legal bill line by line.
So they are basically an auditor for the court.
Exactly. They assess whether the charges are reasonable and permissible according to the specific court order granted.
So even with a punitive costs order, you cannot just hand the taxing master an inflated invoice and expect the opposing side to pay it.
Not at all. The taxing master will still apply rules of reasonableness.
Right.
If your attorney charges an exorbitant hourly rate that far exceeds the accepted norms for an attorney of their seniority, The punitive costs order will not force the opposing side to pay that inflated rate.
So they cap it.
Yes, the taxing master will reduce that hourly rate to what is considered reasonable before calculating what the losing party actually owes.
So what does this actually mean for the penalized party then? They are facing a severe financial blow, but the victorious party still ends up with a shortfall.
Precisely. It is a severe financial penalty meant to punish the non-disclosing party. Their financial liability increases significantly because the net of recoverable items is cast much wider than the standard scale.
Right.
They will pay substantially more than they would have if they simply lost an honest case. However, the victorious party will still, inevitably, have a shortfall between what their attorney actually billed them privately and what the taxing master allows them to recover.
The legal system balances the need to punish deceit with the need to prevent unjust enrichment of the opposing side. They are punishing the liar, but they are not giving the winner a license to print money.
That is an excellent way to summarize it. The court wants to send a very clear message that deceit will cost you dearly, but it maintains strict oversight over how that cost is quantified.
Understanding this nuanced reality really shifts the spotlight directly onto the legal practitioners themselves. It is the responsibility of the attorney to prevent their clients from making these fatal strategic errors.
Absolutely. The ruling emphasizes the absolute necessity for comprehensive client consultations. Legal professionals carry a very heavy burden here.
They do.
They must foster an environment where clients feel entirely comfortable discussing their complete, unfiltered financial circumstances. Attorneys must instill a robust understanding of the repercussions of dishonesty from the very first meeting.
But let us look at the practical friction in the attorney-client relationship. How does a legal professional effectively manage a client who remains stubbornly convinced that underreporting is their best chance?
It is tough.
Imagine you have a client sitting in your office. They're terrified they will not be able to afford their living expenses post-divorce. They are utterly convinced that hiding a 20,000 Rand cash income stream is the only way they will survive the process. How do you handle that without compromising your own ethical duty to the court?
Well, it is a difficult and highly charged scenario, but the attorney's duty is unambiguous. You cannot simply nod, take their instruction, and draft a perjured affidavit.
Yeah.
The attorney must plainly and forcefully outline the risk of financial ruin. You must explain the difference between party and party costs and attorney and client costs, exactly as we just did.
You have to make the consequences tangible for them. You have to explain that hiding 20,000 Rand will not just cost them that 20,000 Rand when they are caught. It will cost them their 80,000 Rand legal fee contribution, their spousal support, and saddle them with the opposing side's legal bills on a punitive scale.
You have to show them that the math simply does not work in their favor. And more importantly, the attorney must make it categorically clear that they cannot be complicit in misleading the court.
Because the attorney's primary duty is to the court.
Yes, the primary overriding duty is to the court and to the administration of justice.
It supersedes the duty to the client.
It absolutely supersedes the duty to blindly follow a client's instructions if those instructions involve deceit. If an attorney advises a client on the necessity of full disclosure, and the client still insists on submitting an affidavit they know is false, the attorney has no choice. They must withdraw from the case.
Wow.
Fostering a comfortable environment does not mean validating an unethical strategy. It means creating a space where the truth can be told so the attorney can deal with the actual facts.
Rather than trying to defend a lie that will inevitably unravel, because the opposing counsel is not going to just take your word for it.
No, they are not.
They are going to subpoena bank statements, look at lifestyle expenses, and perhaps even employ forensic accountants. The truth almost always comes out.
It does. We live in a highly digitized financial world. It is incredibly difficult to hide money effectively, especially during a hostile divorce where the other party likely has intimate knowledge of your spending habits and business dealings.
And when the lie is exposed, the attorney cannot be left standing in court trying to defend the indefensible.
Exactly. This requires a very firm hand from the legal practitioner. It is a profound responsibility to protect a client from their own worst instincts during one of the most stressful periods of their lives.
It really is.
The ultimate lesson from this jurisprudence is that judicial success is paved with integrity and transparency. The courtroom is not a casino, and affidavits are not bluffs.
Well said.
The judiciary is actively protecting the integrity of its processes, and the cost of testing that integrity is simply too high.
Let us recap the journey of this discussion for everyone listening. We started with the 80,000 Rand legal expense claim, along with the maintenance claims that were completely dismissed in the High Court due to the applicant's hidden financial support.
Right.
We traced that judicial zero tolerance policy back to the foundational clean hands doctrine, establishing that utmost good faith is an operational requirement, not a suggestion. We clarified the precise, limiting nature of punitive attorney and client costs orders, dispelling the myth of the blank check while affirming their severe financial impact. And finally, we examined the heavy ethical mandate placed on legal professionals to enforce transparency with their clients, even if it means withdrawing from the matter.
It is a comprehensive framework designed to force honesty in a system where honesty is often the first casualty.
Which leaves us with a final concept to consider moving forward. Given that the courts are increasingly penalizing financial omissions with these severe costs orders, and given how easy it is to trace digital financial footprints today, are we moving toward a future where the burden of proof in family law shifts entirely?
That is an interesting thought.
Could we reach a point where comprehensive third-party forensic lifestyle audits become a mandatory prerequisite before a Rule 43 application can even be filed?
Imagine that.
Imagine a system where the courts no longer rely on the honor system of affidavits at all, effectively turning family courts into forensic accounting tribunals before a single plea for interim maintenance is even heard. It is a fascinating trajectory to watch. Thank you for joining this deep dive. We encourage you to approach your own legal affairs, or those of your clients, with uncompromising transparency.